Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are talking about some fishing licenses, or more specifically, some lobster licenses. And the question that you and I have to engage with in relation to these lobster licenses is, are these licenses assets of a partnership, or are they assets held in some other way? Okay, back in the early 1990s, we have three parties. We've got two parents and their child, parent, parent, child, and they enter into a partnership together, or into an arrangement together, let's say for the moment, to operate a business. That business does a number of things. It does some boat maintenance, it does some boat repair, and pursuant to some licenses for chasing rock lobsters, it engages in some fishing enterprises. And interestingly, these licenses, there are a finite number of them granted, and perhaps to someone with more knowledge than me, that seems fairly trite, right? You want to make sure the lobsters aren't fished to zero. And so each license has some value because it is a fairly scarce resource. And so one of the parts of this enterprise is making use of that license in order to go and do some fishing. Now, parent, parent, child, you remember the people involved. Sadly, after a couple of years pass, one of the parents pass away, and the enterprise becomes parent and child and continues to do this work. Now, as the years pass, and there's a new boat purchased and there are a number of dealings that go on, one thing happens is the joint bank account that has parent's name and child's name on it changes to have child's name and child's spouse's name. And child's spouse we're going to refer to as the plaintiff for today, so we're going to come back to that. So that bank account now has parent, and so it goes from having parent and child's name to having that child and the plaintiff's name on the bank account. And the reason for that, the parties disclose, is in order for the parent to continue deriving an income from this arrangement while also claiming the old age pension, the government entitlements from it. Years passed, and sadly, child dies in 2017, and so we have a position where the fishing licenses continue to be used, and by this stage they're in a sub-license agreement where in essence they're used by sub-licensees who take advantage of the rock lobster entitlements. And so you still have money flowing into relevant bank accounts on account of these rock lobster licenses, but we have child who's passed away, child who you remember was a spouse of plaintiff. Now we're going to change parent's name to defendant today, and in essence what we have in today's proceedings is a claim brought by the plaintiff, who, as you'll recall, as I've said a couple of times, apologies for the repetition, is the child's spouse, claiming from defendant, who you'll recall is the surviving parent. Now what plaintiff says is three things, each of them cascading. Firstly, this business was run as a partnership. The fishing licenses are assets of the partnership. When child died in 2017, the partnership was dissolved pursuant to the relevant sort of statutory mechanics of that. And so the licenses being an asset of the partnership, they ought to be distributed in accordance with the normal course of partnership dissolution, and roughly half and half, but we'll just take that very, very roughly. So that's the plaintiff's first position. The second position they say is, look, if that's not right, then they're tenants in common. They're co-owners who are not joint co-owners. They are tenants in common, each of them with a 50-50 share, is what the plaintiff says. And so because I'm the residuary beneficiary and I'm the executor of child's estate, that 50% share that would have gone to child ought to come to me. That's my second claim. The third claim is an estoppel claim on the similar basis, which is essentially that defendant should be estopped from departing from the position that they were indeed 50-50 owned as tenants in common. Now, if I can just pause us there, I've used this phrase tenants in common a couple of times. Can I just compare tenants in common to joint tenants? And this is going to become relevant as we move on. A tenant in common has a defined share in a co-owned property. So if you and I are tenants in common, you might own 75% and I might own 25%. Or perhaps a more regular occurrence could be you might own 50% and I might own 50%. And when I die, that 50% falls into my estate to be distributed to whomever it is I bequeath my estate to, or pursuant to the rules of intestacy. Luckily for me, I've got my estate plan sort of a quarter of the way to in order, and so at least we've got a will in place. So in this situation, it would be disposed of pursuant to my will, and it'd go that way. Now let's flip the example and say you and I are now joint tenants. Now, if you and I were joint tenants, then the moment I died, you would become the sole owner of the asset. It wouldn't be sliced in half, with one half going pursuant to my will and one half staying with you. It would be that my interest just goes to dust or to smoke or nowhere, and you then become the sole owner of the property. And so that is the position that the defendant contends for today. The defendant says, no partnership, it's not tenants in common, no estoppel claim arises. This is a jointly owned asset, these fishing licenses. You died, your spouse died, and so it comes to me. It's not to be dealt with pursuant to the spouse's will, the child's will. This is the contest that the court is dealing with. Now, if I can spoil the ending, the court finds that the plaintiff's first contention is correct. The court examines the position and says there was indeed a partnership, and so what ought to happen is the fishing licenses ought to be dealt with on the dissolution of the partnership, on the death of the child in 2017. Now, the court makes this finding because the nature of finding that a certain arrangement is a partnership is a matter for reasonably technical contractual construction. It's not about filling in a certain form or some kind of magic formula being in place. The essence of a partnership is that someone with some others is carrying on a business in common with a view to profit. And there are a number of features of a partnership that we've spoken about before and we can speak about again. But in this case, one of the interesting things the court got into was the real nuts and bolts of the enterprise. And what the court found was that sometimes defendant would be captain of the relevant boat and sometimes child would be captain of the relevant boat. Child took entire responsibility for all of the finance and the accounting stuff of running the enterprise, and that there was a sort of blurring of responsibilities for conducting boat repair and maintenance, and that in essence, rather than there being a bright line saying we own this asset together, it was very much treated as an asset of the enterprise that the parties were engaged in. Another really relevant test for is a relationship a partnership or just a normal co-ownership arrangement is whether the parties act as if one of them is agent for the other, as if defendant could go ahead and bind child in some transaction, often things like a lease or the sale of some equipment or something like that, and whether child could bind defendant. Now, as I mentioned before, child held the purse strings while they were alive, and so that was one of the relevant factors the court looked to in finding that the relationship was indeed a partnership. The court went on to complete the examination to say, look, if we're wrong about the partnership, then we would have found it was a tenancy in common with 50-50 shares. And if we were wrong about that, then we would have found that the defendant is estopped from departing from their representation that they agreed that it was a tenancy in common in 50-50 because, in part, the plaintiff had foregone their rights to bring what we lawyers call a family provision claim. So the plaintiff, today the spouse of the child, had written a stat dec at the defendant's encouragement to say, I'm not going to make a claim on child's estate, so they'd suffered detriment as a result of not pursuing the fishing licence point earlier. So an estoppel would have arisen had the court not found there was a partnership in place. So the plaintiff got what they came for, the defendant didn't. And just as a little footnote, one of the challenging factual issues that arose in this case that sort of is a bit of a read between the lines element is that it appears that the defendant was fairly comfortable with the tenancy in common or the 50-50 sort of situation until they bumped into a government record that suggested the licences might have been jointly owned by defendant and child at the relevant time, and that possibility of joint ownership seems to be one of the things the defendant clung to. In any case, the court found the defendant's evidence somewhat unimpressive and had a degree of fabrication and reconstruction to it, whereas the plaintiff was believed on almost all relevant parts of the case. I hope that discussion assisted you, and I look forward to chatting again soon over another coffee and in respect of another case note. Cheers.